Hello everyone, and welcome to this webinar on the topic of challenging activities that harm the environment using Article 9.2 of the Aarhus Convention. So this is brought to you as part of ClientEarth's joint project with Justice and Environment on the topic of access to justice for a greener Europe, funded by the EU's LIFE programme. I am Friel. I'm a lawyer at ClientEarth's Environmental Democracy Programme. And together with my colleague Sebastian Bechtel, we're going to provide an overview of the EU legal framework implementing Article 9.2 of the Convention. And at the end, we'll be joined by Dirk Teßmer, who is a lawyer at the Frankfurt-based firm Philipp-Gerlach and Teßmer. And he's going to give you a kind of practical illustration of Article 9.2 being put to good use to halt coal mine expansion in Hambach Forest. So before I hand over to Sebastian and Dirk, I'm going to cover the crucial questions of, just a second while there we go. The crucial questions of how to get into court in the first place to challenge harmful activities. So that means we're going to cover what decisions can be challenged using Article 9.2 and its implementing laws in EU law, and by whom. So that's the question of legal standing. So first, just a couple of words about the kind of underlying objective of Article 9.2 of the Convention. So as you'll be aware, the Convention covers three pillars of environmental procedural rights for the public, which includes environmental NGOs. So the first is access to environmental information, which we won't be speaking about today. And the second is the right to participate in decisions that affect the environment. And the third pillar is on access to justice. So Article 9.2 specifically is really about this nexus between the right to participate in environmental decisions and access to justice. So really the premise is that where persons have a right to participate, they also have a right to challenge the resulting decisions in court. So this leads me to my first slide, which is what are the measures that we can challenge using Article 9.2? So really these very much depend on the public participation rights that are covered by Article 6 of the Convention. And these fall into kind of two categories. So first, there are decisions on whether to permit proposed activities that are listed in full in Annex 1 of the Aarhus Convention. So I've written out some of those examples for you, but there are many, many more. It also includes any activities that are subject to environmental impact assessment at national level. Article 6.1b then also provides that decisions on proposed activities that are not listed in that Annex 1, but which may have a significant effect on the environment, are also subject to public participation and therefore are also subject to the access to justice provisions in Article 9.2. This also includes decisions on expanding or changing a permit, so it doesn't just apply to that first initial decision on whether to permit an activity. So these provisions have been implemented in EU mostly through legislation, the directive on environmental impact assessments, the directive on industrial emissions, and there's a directive on kind of the prevention and managing of accidents involving dangerous substances. But it doesn't just stop there, because there are other pieces of environmental legislation enacted by the EU that also foresee permitting of specific activities, but which don't include specific provisions on access to justice. These include, for example, the Habitats Directive, the Water Framework Directive, and potentially even waste management decisions under the Waste Framework Directive. So these, the court has extended the provisions of Article 9.2 to these decisions falling under these pieces of legislation, at least the Habitats Directive and the Water Framework Directive up to now. So we'll talk about those in a bit of detail. So first of all, the Environmental Impact Assessment Directive. So these just foresee that all activities that are likely to have a significant impact on the environment should, an environmental impact assessment should be carried out for those, and that public participation is foreseen in the environmental impact assessment procedure. So all of, there should be an EIA for all of the activities listed in Annex 1. And then Annex 2 provides a kind of second list of activities for which an EIA should be carried out, but only if certain criteria are met. So Article 11 of that directive then transposes the terms of Article 9.2 of the Convention almost word for word. So that really gives very strong access to justice rights for the public concerned. And there's been a lot of case law under this directive, which has given a lot of clarity on the kind of decisions that really are subject to challenge under the access to justice provision. So these include, you can challenge directly an EIA that is vitiated by error. Also, you can challenge what's known as the screening decision, so the decision on whether to submit a certain activity to an EIA. Then you can also challenge the final permitting decision, and even you can challenge that permit decision even if it has been ratified by a legislative act. Secondly, there's the Industrial Emissions Directive, which applies to all industrial installations that basically emit pollutants into the environment. And they can only do this according to the terms of permits that are issued by public authorities. So again, there are public participation provisions in the directive so that the public can participate in the decision leading to the permit. And again, Article 25 really transposes the Article 9.2 of the Convention very faithfully. And a lot of case law has given us clarity and shown that we can have access to justice to challenge decisions that grant a permit for a new installation, a decision to grant a permit for any substantial change as well, and decisions that update a permit that include a derogation from the usual emission limits that are set in the directive, and then decisions updating a permit due to it causing significant pollution. So I'll just touch on this briefly. The Seveso directive, which is on preventing and managing kind of major accidents involving dangerous substances, foresees that public participation in certain decisions relating to kind of land use where dangerous substances are present. And Article 23 again refers explicitly to the access to justice provisions in the Environmental Impact Assessment Directive and says they apply to these decisions. So again, these can also be challenged in court by members of the public concerned. So as I said at the beginning, there are other pieces of environmental EU legislation which foresee specific activities which can have a significant impact on the environment, and the Court of Justice has extended the provisions of Article 9.2 to those decision-making procedures, even though the directives don't include specific provisions on access to justice. So there, the court has really relied directly on Article 9.2 with the help of Article 47 of the EU Charter on Fundamental Rights, which guarantees effective remedies. So the first example of this was on permitting decisions that are subject to the Habitats Directive. So Article 6.3 of that directive foresees public participation when a public authority has to permit an activity which is likely to have a significant effect on a protected site. Quickly on the convention to say that the public had access to justice to challenge these decisions, so they can include decisions related to request to participate in the permitting procedure, the assessment of the need for an appropriate assessment, and the outcome of the appropriate assessment as well. And then a few years later, the court applied the same logic to permitting decisions for specific activities related to the Water Framework Directive, which is intended to, well, which places obligations on public authorities to protect certain water bodies. So as you can see, these are the two kind of specific decisions by the court which have extended this right to access to justice to legislation which doesn't include provisions on access to justice, but it could be, this logic could be applied to other areas as well, which foresee decisions on specific activities that could have a substantial effect on the environment. So for example, in the context of waste management. So this brings me to the second question of who then can go to court to challenge these decisions. So it's the question of legal standing. So under Article 9.2, there are two criteria that you have to fulfill to be able to go to court. The first one is that you have to be a member of the public concerned, and the second is that you have to have either a sufficient interest in the decision, or that the decision has the potential to impair one of your rights. So firstly, in criteria 1 in the public concern, this is defined within the convention itself in Article 2.5, which says that the public affected are likely to be affected or having an interest in the environmental decision making. So that is not just a question of whether your legal rights are affected, it's really whether you are simply factually affected in fact by a certain decision. So obviously this is going to depend on the nature and size of the activity. That's been confirmed by the Aarhus Convention Compliance Committee. The public authority should really take into account, firstly, the impact of the normal operation of the activity, but you should also take into account who would be affected by a possible accident. So that was quite important in the context of nuclear power plants, where potentially the public concerned could be thousands or even millions of people across different member states. You must look at the impact on measurable factors, such as the property and the health of residents, but you must also look at unmeasurable factors, such as the quality of life as well. And if you have participated in the prior stages of the decision-making procedure, that's certainly indicative that you are a member of the public concern. So the second criteria is that you must have sufficient interest or impairment of a right. So different countries, different member states tend to adopt one or other of those approaches, either a sufficient interest approach to standing or impairment of a right approach to standing. So we know that member states have a lot of discretion in setting this criteria, but in general, the general principles that apply is that they must be consistent with the objective of giving the public concerned wide access to justice, and that they must comply with the non-discrimination requirements in Article 3.9 of the Aarhus Convention, and I'll talk about that a bit later. So we know that member states that adopt a sufficient interest approach, generally there are less hurdles to gaining access to the court. It's much easier to get into court. That's not to say that once you're in court that all of your rights are respected, but just that initial hurdle of just getting in there is much easier to overcome. Most of the problems are encountered in member states that employ an impairment of right approach. That's because, oh, sorry, I forgot to move my slides. That's because when we go to court to protect the environment, we don't generally go to protect one of our subjective rights. It's really, we go in the public interest. So if you have to show that one of your subjective rights has been breached, that really is quite a substantial hurdle to getting into court to protect the environment. So again, but the problem still remains because it is one of the criteria that are allowed in the Aarhus Convention. So the Court of Justice has had the opportunity to have a look at this in the context of Germany, which employs an impairment of right approach to standing. And they have said that indeed member states have significant discretion to determine the impairment of a right, which is really problematic when it comes to individuals. I'll talk about the specific case of NGOs a little bit later. The Commission, the European Commission itself, when it published its notice on access to justice, and also an Advocate General of the Court of Justice of the EU, have both put forward the opinion that one of the possibilities to enlarge the definition of impairment of a right would be to kind of adopt an expansive approach to the rights capable of being impaired. So to not limit them to kind of subjective public law rights, but also to take a kind of broader approach to say, well, let's look at the use rights that we are afforded in EU law, the rights to use the environment, such as for research and education purposes or fishing and hunting, and define, include those rights within the definition of impairment of a right. So that could have a practical impact on the number of people that could gain access to the court. So I'm going to look at the special case of NGOs when it comes to legal standing. So Article 2.5 of the Convention, when they define the public concern, they specifically say that for non-governmental organisations that promote environmental protection and that meet any requirements under national law, they shall be deemed to have an interest and therefore to be members of the public concerned. Defining whether an organisation promotes environmental protection, I think is generally in the member states that is defined according to the statutes of the organisation and whether they define themselves as organisations that protect the environment, and then whether their activities kind of go towards fulfilling that mission. So that's kind of an easier part of that. And the second part, which is the requirements under national law, is a bit more tricky because it also leaves quite a bit of discretion to the member states to define these requirements that member states must meet. So the convention, the Aarhus Convention Compliance Committee has had the opportunity to look at this, and they've laid out some broad principles to say that yes, the requirements must be clearly defined, they shouldn't cause excessive burden on NGOs, and they shouldn't significantly restrict access to justice. These are kind of broad principles, so it's harder to understand exactly what you mean in practice. So the Court of Justice has looked at this question, but it was in quite an extreme case, so it's still hard to know exactly where the borders of the member states' discretion lie, because in the case where they looked at it, it was a Swedish requirement that for NGOs to be recognised as being the public concern, they had to have at least 2,000 members. And the court held that this really went way beyond the state's discretion because in practice it actually excluded all but 2 NGOs in Sweden from the courts. It's also really clear that the requirements must not discriminate against foreign NGOs. That's in order to comply with Article 3.9 of the Convention. For example, the Aarhus Convention Implementation Guide suggests that therefore it be discriminatory to require an NGO to have been active in a specific member state for a certain amount of time, because that really excludes all foreign NGOs from attacking a decision in a member state that has a transboundary effect. So that's one to watch out for. So then when it comes to the second criterion of having either sufficient interest and impairment of a right, Article 9.2 is really helpful for NGOs because it says quite clearly that meeting the requirements under national law to be recognised as the public concerned means that an NGO is deemed to have sufficient interest or to have rights capable of being impaired. So if you look at member states that employ an impairment of right approach to standing, this really means that NGOs are in quite a preferential situation to individuals because they don't actually have to show that their subjective rights have been impaired before they can get into court. So then NGOs can have quite an important role in bringing public interest litigation in these member states. So in the Trianel and the Commission versus Germany cases that are there on this slide, the Court of Justice said that in Germany, which as I've said, has an impairment of right approach, they said that NGOs that meet the requirements to be the public concerned must have access to justice, and it has taken that approach in the other two cases that I spoke about, where they kind of extend the rights of Article 9.2 to EU legislation that doesn't have provisions on access to justice. So in the context of the Habitats Directive and the Water Framework Directive. And it's really important to note that in the Protect case on the Water Framework Directive, the court went as far as to say that NGOs must be given access to justice, and even if this means not applying national standing rules that conflict with Article 9 and Article 47 of the Charter of Fundamental Rights. So if you manage to overcome these hurdles and actually get into court, what are your rights there? And for that, I'm going to pass you over to my colleague Sebastian to explain further.
Yeah, thank you, Anne. As a quick first point, you may have some questions by now already, or some questions may arise while I talk or while Dirk is talking. You have the ability on the left side of the screen where it says Q&A to type questions. You can do that whenever you want, and we will then reply to them at the end of the session. We have a part that is dedicated to a discussion, but you won't have the possibility to speak, so you just write and we talk. But so you can do that whenever you feel like, whenever it comes to your mind. So I will be speaking as Anne said about the rights an applicant has or that you have when you are in court in a challenge related to Article 9.2. So I'll first give you an idea of the main legal provisions that provide relevant rights, and then give a bit of introduction into 5 relevant topics. These are the scope of review, the standard of review, injunctive relief, remedies, and costs. So I will not walk you through the text of all applicable legal provisions, but what is important to understand is that there are 3 principal sources of law that are relevant here. So firstly, there are principles of EU law that concern how EU law is applied by the member state authorities, including their courts. So this most relevant here are the principles of effective judicial protection and sincere cooperation by the member states institutions that require them to give full effect to EU law rights. Secondly, there are applicable human rights, in particular the right to an effective remedy that is enshrined also under the Charter of Fundamental Rights. And then finally, there's the Aarhus Convention as part of both international and EU law, because the EU has ratified as well, which establishes some basic guarantees for any challenge that falls under Article 9. It's more specific here, Article 9.2. So this is in particular the provision Article 9.4. And so from these legal provisions taken together, one can derive specific minimum guarantees that in particular follow from the case law of the Court of Justice and partially from decisions of the Aarhus Convention Compliance Committee. So first of all, these relate to the scope of review. So this term is usually used to describe the range of legal arguments and provisions of law that a court must consider if they are raised by an applicant. So essentially it delimits what you can claim once you're in court. So as a basic rule, Article 9.2 itself states that an applicant has the right to challenge the substantive or procedural legality of a decision, and this has been implemented again word for word in the relevant EU legislation. So in interest-based system, this aspect is not usually very problematic, but in rights-based system, it has been much more difficult to implement. And the Court of Justice of the EU has therefore also elaborated scope of review, mostly in references from German and Austrian courts, and an infringement case concerning Germany, because these are more right-based systems. In that, the court has first of all acknowledged a big caveat here as well, again related to the rights that individuals hold in a rights-based system, because the court has confirmed that it is appropriate or it is acceptable to limit the scope of review also to the rights held by the individual. So this follows simply from the fact, because in the rights-based system, the logic is that standing in the scope of review both your rights that individual holds, doesn't violate or the Aarhus Convention. And it has the practical effect again that environmental NGOs will have more expansive rights, as already explained. But the court has also stated that there is clear that the requirement that a scope of review is adequate prevents specific limitations, such as material preclusion, which would be a rule that limits claims that can be brought to the courts to those only that have already been raised during a previous public participation phase. And the court also has held that it's not possible to require an applicant to prove that certain procedural errors had mediated a decision just for him or her to be able to raise them. So again, these were two specific rules in the German system that have been struck down by the court. One of the most central questions of the scope of review that's of wider importance is essentially what law or what violations of law you can allege, what kind of sources of law you can rely on. Here, the Court of Justice has again been given some minimum criteria, stated that as a matter of EU law, you must be able to at least rely or bring forward claims that relate to rules of national law implementing EU environmental law and or rules of EU environmental law having direct effect. So essentially the court has said, well, you must at least be able to bring forward any kind of claims that relate to infringements of environmental law. But on this point, the Aarhus Convention Compliance Committee has actually clearly gone further and has stated that Article 9.2 clearly does not only require that you're able to claim infringements of environmental law, but also provisions that do not serve environmental protection. And again, that has led to a change of the law now in Germany with the amendment of the Environmental Appeals Act in 2017. So this is as far as the scope of review goes. The next point is the standard of review. So this is rather the level of scrutiny that is actually applied by the judge when he considers the claims brought forward by the claimant. And this is an issue also in particular in the interest-based system, such as in the United Kingdom. Here, the basic EU rule is that it is left to the procedural autonomy of the member states in principle to apply the rules here. So it's left to the national procedural law, what kind of the degree of scrutiny that the judge has to apply. However, this is limited by two principles, the principle of equivalent and effectiveness, and this will come again later in the presentation. So first of all, the standard review may not be less favorable than those governing similar domestic actions. So basically in cases that do not concern EU law. And this is the really important point here, there's the principle of effectiveness. So it must always be possible in practice and not excessively difficult for an applicant to exercise his or her EU law rights. And this is, in fact, actually limits the discretion of member states quite substantially. So on this point of effectiveness, there's a number of court decisions, or at least court decisions that elaborate on on this in some general terms. Firstly, the court has been very clear that discretion itself does not bar review, so it must still be shown or should be assessed whether the discretion has been exercised properly. And the court has been clear that the system must always allow to effectively apply relevant principles of EU law. And it is always necessary to take into account the purpose of the act to ensure that its effectiveness is not undermined. So in practice, what that means is that the court has been very strong on being clear that the EU law must be effectively applied, and therefore that also requires the judge to consider to a sufficient extent whether there has been an infringement. And when we look at the case, and I've included some here, there we can see that it actually requires a quite substantial review. The most recent case actually here being one of our cases we've been involved in as well, relating to monitoring stations. But there's also cases under Article 9.2 relating to industrial emissions, environmental impact assessment, and habitats. The next point is injunctive relief. So this is essentially refers to a court order to prevent harm pending the final judgment. So basically an interim measure. Here again, the basic rule under the Aarhus Convention is that injunctive relief shall be provided as appropriate to ensure adequate and effective remedies. So essentially to prevent that no remedy can be granted, ensure that a remedy can be granted in the end of the proceedings. The EU law implementation here is mostly through case law. The fact that generally interim relief or injunctive relief must be available is a long-standing principle under EU law. It goes back to Factor 10, which is a case from the 80s. And it also, the court already stated back then that conflicting rules of national law must be set aside. The court has also already applied that in the environmental context, in particular under the Industrial Emissions Directive, stating that the public concern must be able to ask for injunctive relief to prevent pollution, and also to ask when necessary for a permit suspension. And so this would, I think, from the logic apply more broadly and challenges related to Article 9.2 under EU law. On the details, again, this is left to the procedural autonomy, again, limited by the principle of effectiveness and equivalence. So there is not so much elaboration from the court on this point yet. What might be useful to refer to is there's a relevant finding of the Aarhus Convention Compliance Committee, where it has established relevant criteria to be taken into account. So the fact that the court must make its own assessment of the risk of environmental damage, must consider all the facts and arguments that are significant, must take into account the public interest in environmental protection and the precautionary principle. So this might be a relevant factor to refer to, but it's of course quite forward-looking. And it may also be useful to refer to relevant Court of Justice rulings by analogy, where the court has assessed whether there should be injunctive relief with regard to actions of the EU institutions or in infringement cases, such as the recent EARL A2J case. Moving then on to remedies. So these remedies are basically what the court can order as final relief. So basically after the final judgment, if an infringement has been found, what the court can order. Here again, the basic rule under the Aarhus Convention is that remedies must be adequate and effective. And there are some relevant principles of EU law that have been established by the Court of Justice over the years. First of all, and most importantly, there's the principle that the court should nullify the unlawful consequences of a breach of EU law. And then the conditions of remedies are again left to procedural autonomy. More specifically, the court has made some statements in the context of the Environmental Impact Assessment Directive. As Anne has already said, there we have a fair amount of case law. The court has on the one hand stated that if no environmental impact assessment has been carried out and before the development consent has been granted, and this is later asserted by the court, it's on the court to take all general particular measures necessary to ensure that an EIA is still carried out. some form of replacement assessment and replacement EAA is still carried out at a later stage, and that this includes, again limited by the principle of procedural autonomy, the revocation or suspension of a consent that has already been granted, if that's necessary. But the court has also been clear that annulling an impairment in itself is not a violation of property in case that is raised by the defendant. But the court has also very recently confirmed in a judgment that it can exceptionally be acceptable to continue an activity until the replacement EAA is carried out, so that the activity continues until the new EAA is conducted. But the court has established very stringent criteria on this that were specific to that case, basically saying that it had to be justified over a specific public interest, in this case related to energy security. And I've put the reference to the case there. This was a Belgian reference, and it has to be seen how this case law now develops, but it's clear that this should only be exceptionally the case. The other thing the court has stated is that a national court must always make good any harm caused by the failure to carry out an EAA, and that this obligation, so for instance for a damage claim, also applies even if the permit concerned or the EAA, the time to challenge the absence of an EAA itself has passed. You still must be able to bring damage claims. And it's also clear that in principle an infringement of the EAA directive can give rise to a personal damage claim under state liability. And well, the foregoing by its logic would assume to a large extent also to apply to infringements of the Industrial Emissions Directive, CJEU 3. The other area where we have more case law on remedies relates to the Habitats Directive. And here the court has been clear that if no appropriate assessment on Article 6.3 has been carried out prior to a decision of the activity, again, that appropriate assessment must still be carried out at a later stage. And if this assessment then shows a deterioration of the habitat concerned, the Article 6.4 assessment has to be carried out. So this essentially means the court must assess whether the project should still be carried out for overriding public interest reasons, whether there are alternative solutions, weighing the relevant factors, and if not, to take compensatory measures. The other thing that the court has stated as well now in the recent case in Environnement Wallonie is that it also can be okay under the Habitats Directive to continue an activity until the replacement appropriate assessment is conducted. This can perhaps be more criticized because of the impacts on habitats, the situation is actually a bit different than under the EAA directive. And one has to also consider that Article 6.2 of the directive always applies. So whenever there's a deterioration of a habitat, the authority must take appropriate steps. So this is a bit of a different situation. It would, in most cases, seem rather imprudent to continue with an activity that might impact the habitats side until the appropriate assessment is carried out, because that would actually destroy the habitat concerned. So we have to monitor how this case is actually applied in practice. The final point I would like to talk to you about is costs. So Article 9.4 of the Aarhus Convention also states that proceedings should not be prohibitively expensive and cost awards should be fair. This has led to quite protracted litigation and discussion in the UK and now also starting in Ireland, even though arguably the costs are also too high in other countries such as perhaps Germany. What the court and both the court and the Aarhus Convention Compliance Committee have said is you must consider the costs incurred by an applicant as a whole. So you have to consider all the costs to assess whether the costs are prohibitively expensive. And they've both been clear that costs must neither be subjectively unreasonable. So that means they may not exceed the financial resources of the person concerned, nor may they be objectively unreasonable. So what does that mean? It's not very clear, but based on the judgments of the court, some factors can be derived. On the one hand, what is concerned here is not an average claimant, but it's the claim applicant, him or herself, and his or her financial resources. The fact that the applicant is in fact in court and was therefore not deterred, so one might argue then it wasn't prohibitively expensive. Court has said no, this is not a sufficient factor to assess that. And then the court has established their so-called adverse criteria to take into account 6 different factors to assess the costs. And this has started to be applied more by the UK courts, but the situation is far from resolved. There still the proceedings lead to prohibitively expensive awards there. The other factor, of course, is that the cost may not be objectively unreasonable, as mentioned. Here we have even less to go by what that means. What is clear, the court has been clear that if a judge may not take into account at all whether the level of cost is in itself objectively unreasonable, that is an infringement of EU law. Otherwise, there's relatively few Court of Justice guidance. Court of Justice has stated what is the underlying rationale of that, namely that members of the public and associations are naturally required to play an active role in defending the environment. So that may be a possibility to judge against, but it's quite vague. The Aarhus Convention Compliance Committee has established some factors to assess whether a new fee for NGOs should be considered prohibitively expensive. Here they've referred to the contributions that these challenges of NGOs make to environmental protection, whether it essentially would amount to a new deterrent, so reduce the amount of challenges by NGOs, and how it relates to how it compares to other fees. So that would basically be principle of equivalence. So that might be something to take into account. So this is what I just wanted to walk you through very quickly. This is of course just the basis of some relevant Court of Justice judgments. And now I will hand over the floor to Dirk Teßmer, who is the lawyer who he's a lawyer who has brought a lot of cases, permit challenges, and other cases related to the environment in Germany. And he will speak to us, as Anna already mentioned, today about the case of the Hambach Forest, which has received quite a lot of media attention back then and continues to receive, also because of the associated large public protests. And so I will, without further ado, pass the floor to him. I just will quickly make him the presenter.
So, hello everybody. I'm very pleased by the very nice presentation of my person, and it's an honor to speak to you and tell you something about the case of Hambach Forest, which is, well, of course, of some famous in the German jurisdiction, but not closed yet. It's still a hard fight to get the by now temporarily decision of the High Court of North Rhine-Westphalia to get it to a final verdict. Even so, we do hope that there will be a political solution which might then bring the necessity to get a final German verdict out of reach. So, on the base of the things you just learned by the colleagues, I show you now a practical example on how these provisions get into force and how to bring them into action against against a special project. So just to give you a short overview, I will tell you something about the situation and legal background of the lignite mining site and the forest of Hambach. and tell you something about the legal approaches which the BUND, which is the German section of Friends of the Earth, brought to court since 1996, and the restrictions on access to adjudication, and of course the factual and legal backgrounds of the pending cases, which needed some amendments of the German law, and especially on the Aarhus Convention and the jurisdiction by the European Court of Justice. And it's not until 2017 that the claims have been declared admissively. So, and of course, we have a look at the main arguments of the Friends of the Earth in preservation of the forest of Hambach, which we state is a potential Natura 2000 site, which I will explain. This is the main thing in this case. And yeah, I'll give you a quick outlook on how it might get further along. So first of all, let's have a look at the situation and the legal background of the lignite mining site. I've put you some pictures in here to give you just a clue on how mighty that forest has been, and you have to take into account that North Rhine-Westphalia is, especially in this region, not very forestly. There are some forests, but most forests are quite little ones, as you see them here, and then you have no forest at all in this part of North Rhine-Westphalia, at least. And though this has been the forest of Hambach at the end of 1984, the lignite mining site came into action 5 years earlier. So it was around 1979 that the first actions on the ground have been taken in here. So it has been a really huge forest. And this is what is left in 2019. And this are the two parts of the Hambach forest. This forest does not really belong to Hambach forest, but that doesn't really matter. This is all that's left. This forest is a very young one. It was built by the company which brought the earth and stuff on here and built a hill and put some trees on it. But those trees are by now not of any major ecological importance. So, to give you an overview of the most important legal aspects, first very important thing is to know that German mining law consists by a very strict step-by-step approach. So, although there are some big planning law decisions in the beginning, like in the end of the 70s, and then we had 2 more decisions in the 1980s and 1990s. Those decisions do not entitle the mining company, WE, to execute its project. So the company needs to do periodic assessments to get detailed permissions regarding the progression of the mining site within the next 2 or 3 years scheme. So that is maybe quite of some surprise. There is a big project which needs to be done like in 10, 20, 30 years. In this case, it's about 40 years, 30 actually, years that the Hambach Lightning mining site needs to be fulfilled. And even though there are some big decisions, as I told, but these have restrictions on giving the right to execute the project. And in the case that private property needs to be expropriated, then you do have to do a full assessment of the project if it is performed in accordance with all relevant laws. So the mining company cannot be sure that they really be able to fulfill the project until the end. This has been quite a problem for the people who tried to bring legal actions against the mining sites. I have no time to explain that in detail. But now, also it was a very big disadvantage for the people and even for the NGOs. Now it turns out to be a very big problem for the mining side companies. So now this is coming to the core now. We have got European directives on environmental protection, especially the Habitats Directive 92/43, and of course on procedural requirements, which is the EARL Directive, of course. And they became effective after the first permissions have been granted, from which I said that they didn't bring the permission to really execute the project. And afterwards, these directives have come into force. There has been an obligation to take a closer look at the habitats and species which occur in the Humber forest. So at least that is our point of view, which was, of course, denied by RWE. In lots of cases, we brought to court until 1996, actually. So, but nowadays, there is no doubt that you have an occurrence of natural habitats types listed in Annex 1 and habitats of the species listed in Annex 2, which especially is the Bechtel bed, quite seldom bed, which is of importance for Natura 2000. And I now come to the provisions regarding Natura 2000 network, the next sheet. But first of all, you have to know that Germany refused to include the Humber forest, or to even propose to include the Humber forest within Natura 2000, because they didn't want to bring the lignite site into any legal shrubbing, getting the next permissions. And this is something which is not in the words I just used, but it is. You can take it out of some of the sheets from the files. And there has been investigations by the parliament who really bring very close to the sentence I just said. So it's quite obvious, actually, that the only reason why the Humber forest was not proposed to get into Natura 2000 network is, in fact, to protect the lightning mining site from legal trouble. So the baseline of our argumentation is the Supreme Court of Justice, German administrative courts, have ruled that so-called potential Natura 2000 sites, as long as there hasn't been a decision about the implementation of this site within Natura 2000. So Natura 2000 directive protects sites which are within the Natura 2000 network, but this depends that the procedure to bring that network into force has been done right. And if there is a site which is of very big importance for Natura 2000, hasn't been proposed and so hasn't been part of the decision of the European Commission, then it could happen that Natura 2000 will stay incomplete. And because of that, European Court of Justice and German administrative courts have said that in this case, such a site has not to be destroyed. So, of course, Natura 2000 network, which you probably might know, has the main sense to shall enable a network which consists of the species habitats and the habitat types. In this case, is especially the Bechtel beds, to maintain or restore a favorable conservation status. So, and this is about Annex 6, which you can't read, of course, in here. So I put it on other sheets, and we do not go through that because of time. But I would like to point out that if you have a deeper look at that, there are criteria in which case these sites have to be proposed, that's step one, or to be chosen by the commission, which is stage two. And you have this is a sheet which is in the official files, and you do have the baseline bed within here, and you have the A status, which means that this site is very important and very good for the Bechtel beds in this case. So let's put it like that. Sorry. We have two nursery routes with many individuals. It is over 80 individuals of Bechtel beds in the Hambach forest. And this makes the occurrence of the Bechtel bed actually the biggest one, not only in German part of the Atlantic biographic region, but even in if you take a European point of view. So you see the borders of Germany right here, and this is North Rhine-Westphalia. Not all of North Rhine-Westphalia actually. This is North Rhine-Westphalia. You do have the Atlantic biographic region of Natura 2000 in here, and North Rhine-Westphalia is in here, and you got the points on the of the occurrences of Bechtel beds. And talking about individuals and the fact that there are two nursery routes, the Hambach forest, which is just here, is by far the biggest in the Atlantic region. And if you take a look into Europe, do you see the borders of the Atlantic biographic region of Natura 2000 in here? And of course, we do not know how good the data is in the other countries, but you do have significant populations in England and in Belgium as well. And then is in here. I hope you can see my mouse. Actually, I do not know that if you see the mouse pointer, but this is Hambach forest. And it's quite obvious if you look at these pictures that the Hambach forest is of significant importance for the beds. So coming back to the Hambach forest, the final sites. And this would be the border of the Hambach-Rawald Natura 2000 site as proposed. And still in here, we got these two nursery routes and all these individuals. So how to get this argumentation to court? That is quite hard actually, because in German law it's traditional very restrictive on access to justice. The only way you can go to court is that you can convince the court that any act of administration frustrates you in your personal rights, which is property and which is health. And maybe you have some others, but these are the biggest ones. And there is no public admission to go to court if it is just because of environmental matters or a breach of nature provisions. So an exception was made only in cases where an environmental impact assessment has been obligated. But the German administrative courts have ruled finally that no permission regarding the lignite mining site of Hambach needed or needs still to be based on an environmental impact assessment. So this is quite curious, because as I told you before, the German mining law consists of necessity to bring further on decisions. And the first decisions are not the ones who give the company the right to do the whole mining site. And the European Court's jurisdiction has been quite clear that in any case you need furthermore decisions. Then and EIA directive is into force, then this decision needs to get an environmental impact assessment. Unfortunately, we didn't manage to come to European Court of Justice. This is because there is no direct go to that court. You need to convince the German court that they bring forward an action to the European Court of Justice in the Article 234 proceedings, and that wasn't the case in the Hambach files, but this is 10 years ago, actually more, this is 15 years ago. I'm quite sure if that would come to court, to the European Court of Justice, we would get a decision that it is illegal to have permissions on the forescoring of Hambacher lightning mining site without environmental impact assessment. But anyway, it is like it is, and we had all the actions we brought to court in the 90s and the early 2000 years have been declared inadmissible. And so it needed the Aarhus Convention, which is quite old by now, and especially its amendments by the European Community, and you really have to emphasize this, the jurisdiction of the European Court of Justice, which is about Article 9, Paragraph 2 and Paragraph 3, to enable NGOs in Germany to challenge a mining decision by administration before the administration courts. And there have been 4 amendments of German law which regulates the possibilities and requirements for NGOs to forward legal action against administrative permissions, which is on those which do not need EIA. In the case the EIA is needed, there is no problem to go to court. But the other cases are the ones who are difficult, and the case of Hambach Forest is one of those cases, as I told you, the German courts have ruled that no EIA was needed for Hambacher Forest decisions. So, the legal action which brought against the present permissions regarding the lignite mining site are based on Article 9, Paragraph 2 and Paragraph 3 of Aarhus Convention, and especially of the jurisdiction of ECG. And there is something to add, which is not within this topic, but should be added. By now, the Friends of the Earth do have property of a piece of land very next to the forest, and there's another case which is brought to court, which has nothing to do with Aarhus Convention and with EIA directive, which is just because of the property. And but these 2 cases actually are at the High Court of North Rhine-Westphalia as well, and these cases could come to the same ending actually, but just to make things complete. The most important thing is, because of European Court's justification, the German courts now seem to have accepted that all the restrictions on access to justice for NGOs, which still exist in German law, must not be followed, at least not in case where there is good reasons to claim a violation of European environmental laws and provisions, which we really could do in this case. So the German law has a catalogue. Is it on the next sheet? Yeah. Has a catalogue and is meant to be a closed catalogue of decisions which can be part of a legal action to the courts for NGOs. And the permissions we do find in the case of Hambach lightning mining site are argued not to belong into this catalogue, and because of ECG's decisions, especially the ones of Slovakian brown beer cases, where it is said that Article 9, Paragraph 2 and Paragraph 3 has to be fulfilled, and now bring the possibility to fight the lignite mining site and hopefully to save the Hambach Forest on a legal way. And as I said before, the chances are quite good for the forest not to get that legal decision. Even we are quite optimistic that we could reach the legal decisions to save the forest as well. But it looks like we will have a law in Germany by the end of year, or maybe in the beginning of next year, in which consequences there will be no more threatening to the Hambach forest by the lignite mining site, as this should be one of the first ones who get out of business to get coal Kraftwerke, power plants, to get coal power plants out of business. So that's all for now. So I should put on this final sheet, and looking forward to get any questions and hopefully good answers for you. Thank you very much.
Yeah, thank you very much for this, and apologies for these technical problems. I'm not sure how they arose. It really has been a great pleasure that you could join us today. This is really an amazing case that has, rightly so, I think, achieved a lot of attention. I think bringing this case and thereby actually allowing for the potential political decisions that we might now have in Germany has really been very significant to how the further expansion of this mine. And so that has been very great. And I will now hand basically the floor to our participants. So feel free to type whatever questions you may have.